Good afternoon, ladies and gentlemen, and welcome to the Fluxmans sponsored webinar in association with Mail and Guardian on the legal implications for employers and employees in a new era of privacy-centric workplaces. I'm Epstein, the Joint Chief Executive Officer and Managing Director of Fluxmans Attorneys. Our profession abounds with legal jargon and buzzwords. We lawyers have a tendency to use them in order to show how much we know. At Fluxmans, we avoid these common pitfalls in favor of uncomplicated, great advice. We keep it simple and help you cut through all the noise. I have here with me today two of my co-directors. I want to introduce you firstly to Ryszard Lisinski.
Good afternoon, everyone.
Ryszard is a privacy advocate and a commercial litigation specialist. He regularly trains clients and their internal teams in relation to POPIA and the General Data Protection Regulation of 2016. Ryszard believes that when dealing with privacy issues, prevention is far better than cure. The second director on our panel this morning is Lisa Ann King. Hello, Lisa.
Good afternoon, everybody.
Lisa Ann is acknowledged in international publications based on peer reviews such as Best Lawyers, and is widely regarded as one of South Africa's leading employment and human resource lawyers. She has a diverse employment law practice and works closely with the boards of corporate clients to provide advice and strategic guidance in order to implement effective workplace management processes. In addition to her active legal practice, Lisa also heads up and manages our human resources department. In today's webinar, we hope to cover how the POPIA Act will affect your business practically, what you can do now in order to comply, the applicable exemptions to the Act, how to appoint an information officer, the consequences of not complying with the Act, what you should do if you experience a data breach, and the correct way to market directly. You, as attendees, are very welcome to raise any questions you may have, and we will try, depending on the time allowed to us and the number of questions received, to respond to them. You may submit a question by clicking on the Q&A box in the bottom right-hand corner of your screen and typing in the question. Okay, guys. Lisa, maybe you can tell us, what does POPIA apply to?
So, it applies to the processing of personal information, which is entered in a record by or for a responsible party by making use of automated or non-automated means, where the responsible party is domiciled in South Africa, or if not domiciled in South Africa, makes use of automated or non-automated means in South Africa. So typically example of that would be a foreign store that possibly has online shopping, and South Africans have access to it, and they obviously, when they shop, they enter in their personal information into that website. So they would also be expected to comply with our Act.
Lisa, you mentioned a responsible party. Who is a responsible party in terms of the Act?
So it is any public or private body or any person, whether alone or in conjunction with others, determines the purpose and the means for processing personal information.
Okay. And does this Act apply to both employers and their employees?
Absolutely, Ira. We must all understand that obviously in the employment environment, there is a lot of personal information that an employer collects from employees, whether it be their addresses, their ID numbers, their cell phone numbers, their next of kin, religion, sexual preference, possibly health. So all that information falls within this particular Act, and there's most certainly obligations on an employer to ensure that it protects that information in compliance with this Act, and in doing so, obviously protects the employee's rights to privacy. So what that means is that the employer really has to take steps to prevent the loss, the damage, the unauthorized destruction of personal information, and they also have to prevent the unlawful access or unlawful processing of this information. So You'll note in an employment scenario, people are dealing with the processing of this type of information, whether they be training, whether they be recruitment, whether they be promotions, discipline, performance management, ill health inquiries, quality control, customer service. So all those elements, people are collecting continuously in a business and personal information. So it really is imperative that all employers out there understand that they need to comply with this act.
Ryszard, how does POPIA affect one's business practically?
Well, really, what it's done is it's changed the way you manage information. So when you look at personal information now, you're going to have an act that governs the way it's collected, used, stored, disseminated, deleted. You also then need to classify all of that data and identify it as personal information. Critically, I think the thing that's really changed is you now have to notify stakeholders in the event of a data breach, and the Act governs this specifically.
You mentioned earlier personal information, and I understand that POPIA is designed to actually protect a data subject's personal information. What is personal information?
Well, it's really everything you can think of. Okay. It's everything you can think of that relates to a person. For example, your gender, your sex, ID number. In the employment context, the details of an employee's salary in their bank account, an employee's personal file. It even includes personal opinions, if you can believe that.
And I understand that the Act distinguishes between something called special personal information and the personal information you've just described. What is the distinction? What is special personal information?
So the Act has a carve-out for special personal information. It's in essence very sensitive information. For example, religious beliefs, biometric information, for example, a fingerprint, your face recognition on a phone is a good example of biometric information. Interestingly, criminal behavior to the extent that you're not convicted, i.e. You haven't got a criminal record, but there may be a record in your file of some kind of proceeding brought against you, that is classified as special personal information.
And are there any additional requirements that apply to the processing of special personal information, which may not necessarily be applicable to the processing of personal information?
Yes. So there's also a carve-out in the Act, I think it's section 26, which deals with special personal information. And there are some ways of complying with this. For example, with special personal information, as opposed to with general personal information, you always have to get consent unless it's in the public knowledge or it's for a reasonable purpose in terms of a law or legislation. With normal personal information, you could just comply with the 8 steps in the Act.
Ryszard, there's an interesting question that's been posed, and that is whether an ID number or a phone number in isolation, all on its own, can that be considered to be personal information in terms of POPIA?
Yes, provided that, so for in the let's use the ID number as an example. If that can be linked to a person. So the Act makes a distinction of de-identification. That's one of the exceptions to collecting personal information. So with an ID number, if the ID number in isolation can be used to identify a person, then it's personal information.
So, for example, when you're driving to buildings these days and you come to a security guard and he photographs your license disc, and sometimes they ask to take a photocopy of your ID document, or you fill out a form just to get into the building at security. They surely also need to be complying with this Act because they are collecting your personal information in the form of your name, your phone number, and your ID number, and your details of your vehicle.
Correct. And they would also have to attain your consent when taking such information.
Okay.
Obviously, practically, there'll probably be a way of dealing with it more expediently. For example, it all being mechanized with some kind of program where all of this is logged and collected, and the security officer doesn't have an open book. For example, when you go and you log in a hotel, all your details are there for everyone to see. That's going to have to come to an end.
So before we get on to what's a very interesting question from Harry Nochumson, can we just discuss what is processing? What does it mean? The Act deals with the fact that the processing of information is now being regulated, but what does it mean? What can't you do, or what is being regulated in the form of processing?
It's anything that can be done with your personal information. For example, collection of your personal information, storage of that information, disclosure to third parties, transmission, any kind of use of their personal information, the deletion, and obviously the securing of that personal information. So these days, as you know, data security is of utmost importance, and I think everyone would agree that you can say that data is effectively the new oil. So I think it's a great thing that this Act is in place.
I think the jury's still out on that. I'm not sure I agree with you. But the question I want to put to you, Ryszard, is if processing includes storing and deleting of data, which is what you've told us it does, how does one get rid of personal data one is not allowed to possess at the inception of the Act? Let's say at the end of the grace period. What does one do?
Yes. Well, it depends on how you hold it. So physically is probably an easier way of getting rid of it. You'd shred the paper in the type of shredder that you wouldn't be able to read any of the information. That's the most practical way of doing it in an organization. Electronically, it's a little bit more complicated. To use a funny example, the best way of deleting data is to take your chip out your computer and to beat it to death with a hammer. But jokes aside, I think the main qualifying criteria is that it has to be reasonable. So if you've taken all reasonable steps to delete that data and wipe it from your system, I think that would be compliant with the Act.
There's a question as to whether a VIN vehicle number, would that constitute personal information? I suppose, based on what you said earlier, if I merely have the VIN vehicle number with nothing else to put it in context, as I understand it, that may not be personal information. But if I can associate it with somebody, would that be different?
You've couched it perfectly, Ira. That's exactly the distinction. If there's some way of linking it back to a person, then it's personal information. I mean, this is really what marketers do all over the world. If you look at all social media marketing, they group information and de-identify it. For example, they'll collect information of people between 25 and 35 who like golf, and they'll just target you. But in the actual storage of that information, there's no details in relation to you, no personal data. It just has your IP address, and it sends the targeted marketing to you.
And Ryszard, are there any exceptions? I mean, is there any way out of this?
Sure. Well, what the Act says is that the first exception is when it's purely for personal or household activity. A rudimentary example of this would be a handwritten phone book that you have of your contacts, like you used to keep in the old days. That seems to be an exception legislated in the Act. The other is, as we've identified, data that's de-identified. So that means removing anything that can link it to the personal information of a person. When the responsible party is a public body, and they do it in order to safeguard national security, etc. That's also an exception. The final exception is for journalistic, artistic, or literary expression.
Okay, so nothing else is exempt. You have to comply, and that's the way it is.
Yes.
All right, Lisa,
correct.
Perhaps you can tell us, what does an employer have to do in order to be compliant relative to his employees?
So, Ira, the first thing an employer needs to do is actually appoint a information officer. And I know Ryszard will tell you a bit more about what that entails later on in the webinar. But they need to appoint that person, and then they need to do an analysis. and they need to look at the information that they've collected and that they've retained, and they need to ensure that they comply with the following. So they have to basically look at the purpose for which the information has been collected. They need to look at the quality of the information. They need to look at what the information is going to be used for. They need to look at why records are retained and for how long they are going to be retained. And of course, importantly, they also have to look at the security measures that they have in place to protect that personal information. They also need to look at the consents, whether there are in fact any consents on record. And then they need to look at what constitutes, out of all that information that they've got, they have to look at what constitutes personal information and how they will deal with that personal information, bearing in mind that Ryszard did explain to everybody that that personal information requires specific consent, and that special personal information. Employers will also have to then look at conducting a risk assessment so as to ensure what safety measures are in place to protect that information, and obviously to mitigate their risks if they identify any concerns in regard to the safety measures. They need to most certainly look at revisiting their employment contracts, their policies and procedures, their HR policies and procedures, their customer contracts, their supply agreements, and they need to ensure that all those documents have in fact a data protection clause and the relevant consents if necessary, if it is special personal information. They will also be required to ensure that they implement a POPIA policy. And it goes without saying that when any employer implements a new policy within their business, they need to ensure that their employees are trained in respect of that policy. I had a question the other day, and it was asked, how do we present a change in an employment contract to employees? And my answer was that it's important to educate the employees firstly, to train them, to make them aware of what the legislation requires, so that when you present them, for example, with an addendum to their contract of employment, which has all these data protection clauses and the consents, that they understand why they're required to sign it, because as we all know, a lot of the times employees are suspicious when an employer tries to amend a contract of employment. So the best advice would be that they actually provide training so people understand what it involves. Furthermore, they need to ensure that the employees are able to access their own personal information. And that could be by way of, a lot of employers have employee self-service systems. So that may be a means by which I know currently people are accessing information. Yes, that's what they really need to do to ensure that that personal information is protected. So I must say, when you've heard everything that I've said, there's a lot of work to be done for those employers that only really have 11 months ahead of them to ensure that they're compliant by the 30th of June. So it's best to actually start working on this and to get your organization's compliance.
Sure, just listening to you, that's daunting. And it sounds to me like the start of it, Ryszard, if you would agree with me, is having some kind of gap analysis done or some kind of plan or process, because Lisa's talking about going and doing a due diligence on all your contracts, making sure that all the contracts you've got with suppliers have got the right clauses in them, that you've got protection of your own data and that of your employees and your customers, your clients, if you're dealing with third parties. So now you've got to go and check all those contracts, see you've got the right clauses, have the right clauses, and convince your suppliers to put those clauses in. Then you yourself have got to go and put those in your contracts with your employees. You've got to approach those employees. You've got to put safety measures in place. You've got to work out what you need in your business. So you need a process, you need a plan, and you need a gap analysis. It's actually quite a lot of work. And coming out of that, Lisa, you raised a couple of things that are noteworthy and of interest. And the first thing that springs to mind for me is whether, if I approach my employees now to do what you're suggesting, will any of this constitute an unfair labor practice? That I'm now going to go to them and say, listen, guys, because of this act, I need you to sign a new contract because I need consent from you in order to be able to deal with your special personal information or your personal information. Am I going to get into trouble from a labor perspective?
Well, as I said to you, Ira, the best way of dealing with it is obviously to educate people so that they understand that it's not because the employer merely wants them to consent to their information being stored and processed, but that they understand that it's actually legislated and that the employer stands the risk of either being issued with a fine for non-compliance or obviously imprisonment. So it's very important that they understand that, because the minute you get people that are educated on a topic and understand it, then you're going to get buy-in. As I said, if you merely present them, present an employee today with an addendum to their contract of employment, and it's talking about data protection and providing consents, there is going to be pushback. So as I said, I don't believe that they can say that it's an unfair labour practice, that it's a change to their conditions of employment, because it is required of an employer in terms of legislation. But the best advice is to educate before you try and implement a change or an addendum to the contracts of employment. Just on that note too, what I would advise is it's not necessary to redo the actual body of the contract of employment. It may be a good idea just to have it as an addendum, so that people don't get suspicious that maybe you've slipped something else into the contract that they may not be aware of, and then they go and try and take advice, and maybe then you get unions involved that try and then get clever and change other terms and conditions in a negotiating forum. So I would really suggest that for current employees, you have an addendum signed that deals with this particular element, and for obviously new employees, you can incorporate it into the body of the contracts.
Lisa, there's a question here, and it's one that I would have asked if it wasn't asked by one of the attendees, and that is, would passing on of a CV that is being sent to an organization, you get a CV and you pass it on to another organization who's interested in employing people with the same skills, would that be considered as being in breach or doing something wrong with that person's personal information? In other words, can I just pass on a CV I received with impunity?
Well, Ara, I mean, a CV contains quite specific information about a person, and often quite personal information. And I would suggest that any companies that recruit, which is most businesses out there, that they ensure that when they receive CVs, whether it's through an automated process on their website or whether the HR departments receive CVs, that they actually get the applicant's consent. And I don't believe that they'll be able to merely forward it on to another company without contacting that applicant and getting their consent.
Ryszard, if a data subject completes a form themselves, there's another question from an attendee, and it relates to consent. The question is consent then assumed? Can you assume or imply that you receive consent because you asked somebody to fill out a form? Or does the consent statement have to be included in the document? Does it have to be expressed?
It has to be expressed, Ara, and it also needs to be a bit more detailed than that. It needs to say specifically what you're collecting the information for. Ideally, you'd also put in that document the contact person, your information officer, and their details, so that the person concerned can take that information and can update their personal information when they like, or they can contact the information officer and ask them to delete it. So it goes a bit further than just implicit consent. It has to be expressed.
So, for example, where people order stuff online and you are placing an order, you give your credit card details, you give your name, you give your home address, you fill out a whole lot of forms, and you know that come after that, boy, here comes the marketing stuff. You're going to be inundated because they're going to sell your information to every Tom, Dick, and Harry, and it's going to arrive now. When you submit that information, can they just take that information and use it? And if you were representing someone who created such a website, how would you get that consent in those circumstances?
Look, I would always, the whole premise of this act is consent. So I would always start with getting the consent. If the consent is not possible, there are some carve-outs in the act for such a situation. You can market to that person if it's in relation to the same kind of product that they've ordered. But the qualifier there is that there has to be an opt-out mechanism in that marketing. So the way that the Act currently operates, it's a bit of a hybrid between an opt-in and opt-out. So when they're submitting all of that information, I certainly would get a consent by the way of perhaps a click-through agreement, but it's very important where that information is stored, because you have to be able to access it so that you could access that consent if you were ever audited by the regulator. So when working out with the website administrator, you'd have to have some kind of click-through agreement, very similar to terms and conditions that you would click through or tick when buying an Apple product, or etc.
So you can actually build it into your website and keep copies and retain evidence of that consent if ever queried by the regulator. That would be the advice.
Ideally,
Ryszard,
yes.
For training registers, you keep the name, you keep the ID, you keep the gender of the person who attends a training session. And when a company asks for this register, when you attend the training session, is this legal? Is it allowed? Are they allowed to ask you for this information? It's the same as when I drive into a building. I get so irritated. They take all my personal details. When I go through a boomed area, there's somebody standing at the boom taking down all my details, and I want to say to them, have you heard of POPIA? You're not allowed to do this. What are you doing with my information? I want to know you're destroying it when I leave the area. Are they allowed to do those things?
So it has to be for a lawful purpose. So if they can't show, so for example, the training register, if you're submitting it to the body that deals with training and it's legislated in legislation, POPIA allows that kind of collection, provided that all the security safeguards are in place. The collection of your data at a boom, I would say that the only purpose is security, and what they would need, some of the information they ask for security purposes, I think they'd have to really trim down those forms. And I would prefer it not to be in the take the shape of a form. I would mechanize it if possible.
Ryszard, there's a question here that's been posed about our COVID registers. You know, we've got them at reception. When you come to Fluxmans, you have to have your temperature taken. We keep a record of the temperature. We keep a record of who's visiting. We keep your contact details, your name, your ID number, your telephone number, your address. And we do that so that if anybody that you meet happens to have COVID, or if you phone us afterwards to tell us that you've been exposed to COVID, we're able to make contact with you and tell you you've been exposed to someone in our office. What happens? What should we be doing with those records?
Okay, so that's exactly what I've spoken about. That's for lawful purpose, legislated. It's the regulations in terms of the Disaster Management Act, and it's also in terms of the Occupational Health and Safety Act. I think it's Section 27. What the Act says, and if you read it in conjunction with both acts, is that you need to take that information for the lawful purpose of dealing with COVID, and obviously to contact people at a later stage in the event that there's a COVID disaster. So that information, I think the Act gives you about 6 weeks to delete it post the end of COVID. Who knows when that will be? So all of that is legislated and you're entitled to do it. But I would recommend that you keep all of this information in a safe place, that the people that access it are only those authorized to access it, and I would try limit it to a very low number of people, so as to protect the integrity of that information.
Ryszard, I'm very excited to tell you, as you know, that you are Fluxmans compliance officer. The reason for that is because I understand from the Act that if I don't appoint you as the information officer, I'll become liable under the Act as the CEO of the environment. So the best advice we can give all the CEOs out there that are listening is they need to find themselves a Ryszard that they can appoint as the compliance officer in order to avoid personal liability. Am I correct? How do I go? Well, how do I appoint an information officer? What are the duties and responsibilities of the information officer? And am I correct? Do I get exculpated from liability by appointing you if something goes wrong?
Okay, that's a few questions. I'll answer them one by one if I can. To start off, I think there's a difference between a compliance officer and an information officer. The compliance officer is the compliance officer in terms of the COVID regulations. The information officer is someone you appoint in terms of POPI, and that information officer is effectively your POPI champion. They encourage compliance with the Act within an organization. They handle requests relating to personal information. They work with the regulator if there's a complaint and the regulator investigates. And they effectively, their whole job is to ensure compliance with the Act by the organization. Now, if you want to appoint an information officer, the regulator has published the registration form, which you can find on their website. Effectively, what you need to put in that registration form is the name of the information officer, the designation in the entity. They can also appoint deputy information officers if it's a large entity to help them. You'd have to put the name of that deputy information officer. You'd have to put their details, electronic mail, etc., their address, and every other deputy information officer that you appoint, their details would have to be on that form. To address your question of liability, I think you need to distinguish between criminal and civil liability. The civil liability, i.e. the fine, that will go to the entity, but the compliance officer will be the one that's guilty of a criminal infringement. So it's very important that you appoint someone that you trust, that's trained, that will mitigate against that kind of risk.
You've convinced me, Ryszard. You are most definitely the POPIA officer. And that means you're the guy who faces the criminal charge and not myself. What is a POPI policy, Ryszard? We spoke earlier about having a gap analysis, having a plan, having a policy. What would one put into a POPI policy? Does one need a POPI policy?
Absolutely. I mean, that would be one of the starting points when you're trying to get compliant by next year, June. A POPI policy is effectively a policy you put in place to regulate the management of personal information, as well as special personal information. It should be regularly updated, and it's the policy that the information officer implements. That's very important, because I don't see a point of a policy unless that you're going to lock in a back office and never consult again. I think it's very important that the information officer and his or her deputies regularly update this policy and implement it. What happens after this is, once you've got all of this in place, you obviously have to publish what they call a POPI manual on your website. It's effectively a combination of the Promotion of Access to Information Act manual and the POPI manual. And it'll have all of the details of your information officer and deputies, how you contact them, and how you effectively or the mechanisms in place, that the organization protects your information, and how you would go about deleting it if you'd like to.
Ryszard, there's a question here I want to ask you. State entities, namely the Department of Health and Education, yes, by way of example, are they required to be compliant?
Yes, but there's the caveat that if it's for public security, etc., they're allowed to process it without consent. But yes, they would have to be compliant. It would make no sense for them to have effectively a get out of jail free card just because they're a public entity.
So we, for example, keep files for 5 years and then we destroy them. I saw recently from the Law Society a note that we now have to keep our records for a period of 7 years. Our insurers also have got a requirement for us to keep our information for a certain period of time. There's a bit of a conflict between these requirements and POPI, which says that you need only to keep the information for as short a time as possible, and you need to delete it. I also understand that the data subject, the person whose information you're keeping, can request you to delete it as well. What happens where the data subject asks you to delete it, but we're required to keep that information? Can we keep the information for the 5 years, the 7 years as required? Or yes, are we obliged to comply with the data subject's request?
Well, see, that's the loophole. If it's what POPIA says in relation to other acts is if there's a lawful purpose or legislative purpose for keeping that information. So in this instance, if the data subject wrote to you and said, please delete it, you'd write back to them and say, we're keeping it for this purpose. This is how it's secured. You're welcome to update it, but we can't delete it until the 5-year period is up because this is what this act says. And that would be the way of dealing with that kind of query.
Okay. Does POPIA, Ryszard, mean the end of junk mail for us? Will people stop selling our email addresses and cell phone numbers to marketers?
No. So what POPIA means is that you've got a way of complaining. And in terms of the act, I alluded to it earlier, it's a hybrid between an opt-in and an opt-out. What this means, so the Electronic Communications and Transactions Act used to have a opt-out mechanism, or still does, where you'll receive marketing email. At the bottom of the email, it'll allow you to unsubscribe. And all legal marketing emails should have that. For someone calling you, they'd also have to give you that. So if it's the first time they're using your information, before they even contact you, they'd have to get your opt-in to send you anything. So that's the partial opt-in portion I'm speaking about. And then every time thereafter, they'd have to give you the opt-out opportunity. So if you want to get rid of any of that kind of stuff, it's within your power now already. You just have to listen to that first inquiry, and thereafter you can opt out.
Okay, thank you. Lisa, who is the data subject in the context of an employment contract?
So firstly, Ara, the Act refers to any person to whom personal information relates is regarded as a data subject. So if you look at it in employment environments, it would be your job applicants, former job applicants, current employees, former employees, fixed-term contractors, consultants, seconded employees, even employees that are placed at your premises through labor brokers. Those are all regarded as data subjects, and their personal information is protected in terms of this Act.
Okay. Should employees be aware of complying with POPIA when dealing with COVID in the workplace?
So, Ira, most certainly, obviously what's I've seen happening at clients and at our own offices is that we have got information forms that either employees or our clients fill in, and that should provide you with a form of consent. As Ryszard said, is that there is legislation, obviously all the regulations in terms of the national disaster, and the Occupational Health and Safety Act doesn't specifically require the consent, but it's always best to have the consent. So what we've done in our firm, for instance, is we've got a proper COVID policy in terms of which we've obviously set out exactly what is required of people, what information we require them to provide us with. They're obviously required to provide us with information about their comorbidities, about symptoms that they may have, and of course we have to be informed if they test positive. Now, I have had clients that say, well, hold on, if somebody tests positive, shouldn't we be able to protect their identity in terms of the fact that they're positive? But the legislation has provided that you are obliged as an employer to report that positive case or any other positive cases to the Department of Health. So there is a carve out in terms of what we're currently dealing with COVID. But as Ryszard correctly says, it's always better to err on the side of caution and rather get that consent.
And how would employers, or how should employers deal with information about trade union membership?
So our trade union membership is often a very tricky situation in any employment environment. And what they need to bear in mind up front is that trade union membership is regarded as special personal information. So they need the consent of the employee when going to process trade union membership details. Now, a lot of employers might say, but hold on, an employee will come to me, they will present me with a union membership form as well as a stop order form, and they'll say, is that not sufficient? And our advice would be that those current forms, as I've seen them, do not specifically provide consent to the employer to process that information. And we would definitely advise that the employer has a separate document and has the employee sign that in giving them that information, they are entitled to process it for the purposes of deducting the relevant subscriptions at the end of every month off the payroll.
Okay. And how should employers be advised to deal with employment references going forward?
So, Ira, that's always also quite a tricky situation, because if an employee is left under bad terms, the question is always asked, well, what is our obligation if there's a phone call to say, well, was this person a really good employee or not? And it places employers in quite difficult situations because they're not always, sure of what to say. So the Act most certainly permits the obtaining and granting of references. And by references, it's not just a reference, an oral reference or a written reference to say this person worked for me and this is what they were like. It would also include criminal or background checks. But where I would definitely caution the viewers today is that they need to be careful when dealing with the exact type of information that they're giving. For example, if an employee has been terminated on the grounds of theft in your workplace, and you as the employer haven't laid a criminal charge, which is often the case, you've merely gone through a disciplinary process, the person's employment has been terminated due to misconduct as a result of the theft, you aren't at liberty to disclose that information when giving any reference. Only if the employee has actually been convicted of the crime can you disclose that information. So I think that's something that everybody should be very cognizant on, because it's something that could easily slip through the cracks. And they need to just understand that you can only disclose it if there's a criminal record and the person has in fact been convicted. They must also be careful when dealing with biometric information, because that also forms part of special personal information where you're going to need consent.
Thank you. Ryszard, what is automated decision-making in terms of the Act, and how is that affected by POPIA?
Okay, so automated decision-making is when a program, I think many people would use a program to collate all of the employment information, such as leave, etc. When a program automatically renders a result or collates all of that information, and it creates an electronic file of that information. What POPIA says, and there's a carve out there, is that the automated decision making, so any decisions made in terms of by the software itself without human intervention, are not to be used against that person who the information is relating to. So there's a specific carve out in relation to automated decision making.
Ryszard, can an employer process employee information outside of the borders of South Africa? Does the Act allow that?
Only so that's dangerous territory, because ultimately the responsible party, i.e. the employer, will always retain the liability for that information, regardless of whether it goes across border and it's processed by another party. What I would say in that instance is that the employer must ensure that they check where that information is going to, and who is processing that information, and what their policy is that's in place, and how they secure that information. Especially if they've got contracts with those third-party processors, I would recommend that those contracts have a few clauses in them, the least of which is number one, a warranty relating to their POPIA or GDPR compliance, and the other is a limitation of liability, i.e. or an indemnity, where they indemnify you in the event that there's a breach. For example, if someone sues you as a result of the breach as a responsible party, you would then look to them to make good for that amount.
Ryszard, there's a wonderful question here. Somebody wants to know whether they can appoint someone at Fluxmans to be their company information officer, and I'm going to respond to that by telling them that you're available. I don't think that's... Do I need your consent? Let's frame the question differently. To appoint you as the information officer, would I need your consent?
Absolutely.
So
I don't know if you could afford me.
Okay. Ryszard, does the GDPR...
Yeah, no, you can definitely do it. Yes.
Maybe you can just tell us a little bit about what GDPR is, and then tell us whether or not GDPR applies to South African companies. Do we as companies operating in South Africa need to be aware of GDPR? Do we need to comply with it?
Okay, so a lot of people think that there's no privacy legislation in place, and there they'd be wrong. The GDPR is the General Data Protection Regulation. It came into effect about a year ago in Europe. And in effect, if you process any data in relation to individuals of the EU, say, for example, they go on your website and they fill in details and you process that information, you are hit by the act. A lot of people have taken the route of not complying because it's expensive, but I can tell you, if you get the kind of fine that you would from the GDPR breach, it's far more expensive to pay that fine than to comply with the GDPR.
Okay, thank you. There's a question here that I'll answer quickly. It says, as a sole proprietor of a private healthcare practice, am I automatically the compliance officer? I would say yes, you are. And if you don't go and appoint somebody else, then you're going to be the compliance officer.
And I think, sorry, just to step in there, there seems to be confusion, as Ryszard distinguished, is that in terms of POPIA, it's the information officer. In terms of COVID, it's the compliance officer.
Thank you.
Correct.
That's correct. What are the consequences of not complying with GDPR? You've said that, I mean, they're not going to stick me in jail, Ryszard, not while I'm sitting here in South Africa. And if they fine me, what are they going to have to do? Come and get an extradition order to prosecute me in the EU? If they fine me, are they going to enforce that fine on me here in South Africa? Are these consequences a reality?
Well, what if you have a subsidiary in the UK, for example? They will get an order and they'll go and enforce it on that subsidiary. So I don't think you're entirely scot-free. Yes, it's difficult, but they are currently instituting huge fines in the millions of euros. And once they've fined everybody there, I'm sure they're going to look to us. Or throughout the world. It's only in its infancy, so when it develops, they're certainly going to develop proper ways of doing it. So I would say be careful and rather hedge your bets and comply with both acts than take the non-compliance approach. And to answer your question, it can be up to 20 million euros or 4% of your global annual turnover, which is huge. It can cripple any entity.
So, Ryszard, maybe we should start giving advice to the revenue over here, because does our act apply to non-South Africans who are using the data of South African citizens? Would the revenue over here be able to collect fines that are imposed? Would the same work the other way?
It's a good question, Ira. I think time will tell. It's still developing, so we'll see how the two acts interact with each other.
Thank you. Okay. Ryszard, how does POPIA affect direct marketing? If I'm in the marketing game, am I still allowed to do direct marketing? What are the requirements? What does the act say about it?
So, yes, you can. It's not outlawing direct marketing altogether. You just got to do it in the right way. So if someone's already part of your contact list and they've already sourced services for you, from you, you can send them any kind of direct marketing. on the basis that your emails have got that opt-out mechanism, so that they can conceivably link to the bottom, click on that and opt out. If you've never contacted them before, I would send them a form saying, we're whoever, this is what we do. Can we send you marketing in relation to this? And you'd have a opt-in click-through mechanism to record this, and thereafter you could then send them marketing. So effectively, it's getting rid of cold calling without ever having had that information to start with for a lawful purpose.
Okay. Ryszard, there's a question here which says, can we comment on retrospective penalties? How far back can the regulator go where there's been an infringement? Would you like to comment on that?
I don't think it's retrospective. It's only, and if that's why they've given you a year to comply, it's only in effect from 1 July 2021.
Cool. What do I do if there's a data breach in our environment? Or what are you going to do as the information officer when something goes wrong over here? I remember recently we put some of our clients' money with Nedbank. There was a data breach. Nedbank advised all their clients that they'd had a data breach. We advised our clients that their money that had been placed with Nedbank had been compromised, and a lot of clients were very unhappy. What are our responsibilities? Do we just have to write and tell clients? What do we have to do?
Well, first you need to find out exactly what information was compromised. That's always good practice. Then you notify your employees and customers that a breach has occurred. And if you've complied with POPIA and the breach still occurs, despite you putting in all sorts of reasonable security measures, etc., I think the consequences for you are diminished greatly. If you don't inform of a breach and it's found that you purposely withheld it, I think the consequences are far greater, and the regulator won't look kindly on it.
Okay. There's a question here about a suggestion for a startup company. They don't have an employee who's trained to be an information officer. They don't have the budget to hire an additional employee that can oversee this. Are you allowed to outsource this to a third party?
The information officer aspect, yes, absolutely. Yeah. It depends on budget-wise. I mean, I would rather, obviously, if they don't have the human capital to do it, I understand. You would try to outsource it. The costs of that would vary depending on the type of information, etc. And the amount of work involved. But for a small corporation like that, I would, as the CEO or the managing director, whatever designation you hold, I would get some kind of training. And it really isn't that burdensome if you've only got a few staff members to implement this. And I would take ownership of it. That's the most cost-effective way of doing it. To get someone to manage it for you when you don't know exactly what they're doing, it's not a risk-averse approach. I would take ownership of it, and I would get trained, and I would deal with it.
Ryszard, here's a question. Do you have to maintain both a PIA manual and a POPI manual? Can you have a hybrid of the two and have one manual now?
Yes. Yes. So they make mention of a POPI manual, but what the regulator now does is the regulator is the body that governs the PIA Act as well as the POPIA Act. So I would say, yes, you can have a joint manual on your website, provided you have all the information required by both acts. And I would do it just in one, because it can be quite burdensome to have all of these documents on your website. Terms and conditions, privacy policies, PIA manuals, POPIA manuals. I would rather consolidate it into one document.
What security safeguards would you recommend for the audience out there to have in place? My understanding is that each business needs to be analyzed independently. What's good for our firm is not necessarily going to be good for a medical practice, is not necessarily going to be good for a print shop, won't be good for a catering business. I understood that we need to actually go and look at each individual business, analyze the nature of the business, and then determine what's required for that business. But from a security perspective, are there security safeguards that everybody should be putting in place?
Well, look, ideally, you'd want to comply with international data protection standards. That's ISO 27001. But if that's too costly to comply with for the smaller organizations, I would say just be practical about it. Appoint your information officer, train them. Work out exactly and do a due diligence on exactly what information you collect, where you store it, what kind of security you have for storing that information. I mean, encryption is not that expensive, and I would encrypt files and make sure that the people that access it are trained, and that you limit your exposure to many people accessing files. So the massive problem here is the human element. The more people that access the files, the greater the danger is, because really technology is not going to fail, humans will.
Ryszard, there's a question here as to what is the status of personal information already in the public domain? Will POPIA apply to this? If I can get that information from the public domain, and it is personal information, but it's not provided to me by the data subject, am I allowed to process it and do what I like with it if I gathered it myself, or am I still subject to the requirements of the Act? Because it still constitutes personal information of a data subject.
Well, that's tricky. As I read the Act, anything in the public domain you've put out there for everyone to see. So if you haven't secured it yourself, you can't then very well ask other people to secure it for you. If you put your details out on Facebook, that's your problem. You shouldn't have done that. And that data can be used, in my opinion. Everyone has a responsibility to secure their data on social media, and if you don't do it, you're allowing other people to exploit it.
Ryszard, I don't think we covered what the consequences are. We spoke about the consequence for non-compliance with the GDPR. What are the penalties or consequences for non-compliance with POPIA here in South Africa, where they may be able to track us down and fine us?
So the fines, in terms of the current legislation, are up to 10 million rand, or you could have a prison term of up to 12 months. It depends on the severity of the fine or the infringement. For example, not complying with POPIA, there will obviously be a civil fine in relation to that. But if you interfere purposely with the regulator and their duties, I would imagine that there'd be a criminal aspect to it.
Lisa, there's a question here. We use an external company to run our payroll, who have access to our employees' personal information. What contract should we put in place to protect our company, and could Fluxmans prepare this agreement?
So, Ara, I would most certainly recommend that the contract between the company themselves and their service provider, which is this outsourced payroll, that needs to contain all the relevant data protection clauses. And Fluxmans could most certainly assist with any of these documents that we've discussed this morning or this afternoon.
Thank you. I see we've lost Ryszard. Are you still there? Have we lost you, or are you coming back? Back. Great.
I am.
The question has been put to us as to where one can access the Fluxmans POPIA manual. It's not on our website. Does it not need to be published? I can answer that question. We are busy preparing it. We don't have to publish it yet. I think we've got 12 months to be compliant. So in due course we will, but I happen to know this client, and I have no doubt that he's just looking to copy our manual. So we're going to send him an account anyway as soon as we publish the manual. Guys, we only have 1 minute left. I'm afraid that's really it for the moment. We're not able to take any more questions. I want to thank the Mail and Guardian for hosting it. Thank Lisa and Ryszard for their assistance here. It looks like there's a lot of work ahead of us in the next 12 months. I'm not sure that we are going to meet that deadline. It may well be extended, but there's a plan to be put in place. There's a manual to be put in place. There's a gap analysis to be put in place. There's a lot of work to be done, due diligence on your contracts, updating of your contract, giving you wording for your contract that you can use. And we have the capacity, we have the people, the knowledge, and the skills to assist all of you out there. If you need our services, if in any way we can be of service to you, please don't hesitate to contact us. This webinar has been recorded, and all of you on the list of attendees will be receiving a copy of this webinar via email in due course. Thank you very much for your attendance.
Thank you.